I just want to make sure.
Sure, you guys have got all the equipment here.
Kan you on air? There you are. For you to stop now.
Oh, so I can start. Good day, everyone. My name's Ismail Hussein, and we're going to talk about litigation strategy. Now, before I start, just let me go through a few things so that you can get the most out of. I must get this out of the way. I hate these things. I would rather be talking to you directly in a lecture room or in a. But unfortunately, we're stuck with this. Now, what I want you to do is sit back, relax, and listen. Don't bother to write notes because you've got the notes that's been sent to you. All the main points are covered there. I would prefer it if you listened and tried to understand the various concepts. The thing about being a good lawyer is the ability to understand, to solve problems, and you have to apply your mind all the time. So when you're listening to me talking to you, apply your mind to what I'm saying. You will have an opportunity to ask questions later. That's one of the things I hate about is that I can't, you can't put up your hand and I can deal with your question and then move on. You have to put your questions in writing and I'll deal with it at the end of the session today. So when we talk about litigation, we are talking about lawyers who go to court. Now, as far as the practice of litigation is concerned, that has changed dramatically. I've been a litigator for 40 years, and I can tell you it has changed completely. It is now what I did as an attorney and as a senior counsel has changed completely. And I will take you through those changes, and you need to prepare yourself for the new order. Litigation is no longer called litigation to start with. You will see that many of the law firms don't use the term litigation department anymore. They don't put themselves out as litigation experts. Now it is dispute resolution. And that's where the mindset has to change. It is about resolving disputes. It's not about fighting the other side. That is the biggest change. Although the system we use in this country and most of the Commonwealth as well as the United States is still an adversarial system. You are not expected to have an adversarial approach. And I will show you how to go about doing this very effectively. One thing you have to accept, to be an effective lawyer, you must be a person who applies your mind. There's a tendency amongst lawyers to copy and paste everything from a precedent. Particulars of claim, notices of motion, heads of argument, even a letter of demand comes out of a precedent. That has to stop. The problem with being a slave to precedent is that you stop applying your mind. So if you are a copy and paste expert, then you have to reinvent yourself. Otherwise, you will not succeed. Now, here's an interesting thing to start with. I call it the first principle. And I borrow this from Lord Brown Wilkinson, who is an English law lord. And he said, the first principle of judging is dirty dogs don't win. Now, that's quite an interesting thing. And when I first read that, it struck a chord with me, because that one comment captures everything about the new order in litigation. What does it mean, dirty dogs don't win? Well, it simply means that if you come to court, not because you have a genuine dispute, not because you need relief of some sort, but you come to court to abuse the processes. You are there to delay someone. You are there to prejudice someone through litigation. You're using litigation as a strategy in business. That is no longer allowed. But the most important thing about this first principle, and I will mention this regularly, when you go to court, but you don't have a version, in other words, your story is improbable, your version is not likely to have happened, then you are the dirty dog and you will not win your case. Simple as that. But what's happened in modern litigation is that judges are being trained to put their finger on the dirty dog. If you come to court and your version of the facts is a load of nonsense, you will not get away with it by simply saying, well, my lord, those were my instructions. Because what has changed is that judges see lawyers as officers of the court. They are there to assist the judge. And if you are going to present a judge with a nonsensical version or an improbable version, you are not being helpful. And the judge might be inclined to punish you. Now, the second principle, and it's related to what I just said, the facts are the most important part of your case. You must know what happened according to your client's version of the facts. Now, this is the start of dispute resolution. There's no lawyer nor judge can resolve a dispute if they don't know the facts that gave rise to the dispute in the first place. Lawyers need to understand what their own client's version of the facts are, and then they also need to find out what the other side's facts are. Now remember, it's not about the law. The law comes later on. You cannot apply law if you don't know the facts. There's the third principle. I mentioned it already. It's related to the first one. Never go to court with a version that is improbable or implausible in relation to the circumstances of the case. If you do go to court with such a version, you are the dirty dog. Because a judge is no longer going to accept that, well, those were your instructions. As a lawyer, you should be able to work out that based on the circumstances of the case, your client's version is either probable or it is improbable. Now remember, the onus of proof in a civil trial still remains on a balance of probabilities. What this means is judges are not there to seek the truth, because they will never know what the truth is. But one thing judges can do is to work out, based on the versions of the parties and based on the circumstances of the case, what is likely to have happened and what is unlikely to have happened. When a version is probable, it is persuasive, you will discharge the onus. If the version is improbable, you are going to lose. So, the first thing is you need to change your mindset. You have to stop being adversarial. Now, I started teaching lawyers about 30 years ago, including litigation. And I remember I was a young lawyer myself, and I used to say very aggressively to attorneys and advocates, the purpose of litigation is to win. Now, that was me saying you win at all costs. The idea is to defeat the other side. And we behaved in that way as lawyers. We never cooperated with each other. We didn't talk to each other. We only talked settlement at the doors of the court. All of those things are no longer tolerated. So the adversarial approach is not tolerated. And I will show you a better method of resolving disputes. The first thing to do is to resolve the dispute without having to start an action or an application. But we know as lawyers that there are those disputes which are genuine disputes and require a court to intervene. So the strategy, I'm going to split it into 4 parts. The first part is what we lawyers call obtaining instructions. But I prefer to say taking instructions does not necessarily mean an instruction or a mandate to proceed by action or application. It's far more than that. Obtaining a mandate, those are formal requirements. They go along with things like FICA requirements, POPI requirements, and so on. What I'm talking about is you having to obtain all the relevant available facts. That's the first part. The second part of the whole strategy is how do you go about formulating a cause of action or a plea that will persuade a judge? Now, I can tell you, having spent many years on the bench, that 9 out of 10 times when you read the pleadings in the High Court, what you will find is that when you read the pleadings bundle, which is what judges read, that's the particulars of claim, the plea, and the minutes of the pretrial conference. Having read that, most of the time, the judge finds that he still doesn't know what the case is about. And that's terrible. If a judge is not persuaded that you have a case, in chambers where they're sitting and reading the papers, you are already on the back foot when the judge walks into court. The judge is not impressed. The judge will then want to sort this out in your opening statement, and it may be too late then already. So what you need to know is how do you take your available facts and then formulate a cause of action. Draft particulars of claim so that the judge can see what your case is. Drafting particulars of claim out of a precedent doesn't help anyone. It doesn't assist the judge. It doesn't tell the judge what happened. It doesn't tell the judge what your client's case is. Likewise, if you file a plea that amounts to a bare denial or amounts to an evasive plea, it is not persuasive. A judge is against you already. Then I'm going to go to the third part, which are the pretrial procedures involving things like discovery, experts, managing experts, attending case conferences, and judicial case management. These are matters that are taken very seriously now. Most of you know, if you're from this province, and I can include the Western Cape as well as KwaZulu, where you will not be given a trial date unless a judge, a case manager, or even a registrar certifies that you are trial ready. It means that you have complied with all the pre-trial procedures. It's an integral part of your strategy. And then the last part or phase is the trial itself. Now, just let me warn you, trial advocacy itself is outside the scope of this program, but I will deal with it. And I will deal with a number of aspects of a trial, which will make you more successful. Now, before I get on to the first phase, this is something I have to deal with. It is a fact that our uniform rules has not kept up with modern practice. Our rules are so outdated that they have to be just thrown out of the window and replaced. Whose job is that? It's the rules board. And the rules board is dysfunctional. It doesn't update rules. It should be rewriting our rules. We get bits and pieces coming out here and there, and it doesn't really work. So how did we solve the problem? The judges decided to take some steps towards streamlining litigation, bringing the new methods and so on. They do it through practice directives. The directives are issued under the hand of the judge president or his deputy. And the problem is it applies only to that court. It does not apply anywhere else. What it means then for practitioners is that there's no uniform practice anymore. I mean, if you take 3, or let's make it 4 of the busiest high courts in the country, that's the 2 Gauteng divisions, Western Cape, KwaZulu. You can be sure that the practices are different in each one of them. There's the uniform rules, then there's the practice directives. You have to know both. My advice to you is before you commence action, that's before you even issue the summons, first read the directives of the court where you intend to bring the application or action. Now, most of us have to bring cases in courts that are outside our provinces. So you end up appointing a correspondent and so on. But for you to keep good control over your own case, you can't rely on your correspondent. In fact, most people know that you really shouldn't rely on your correspondent. You have to read the directives yourself. For any action, you have to comply with case management. Trial certification procedures have to be complied with. That's part of case management. You will have to attend case conferences. Now, in the past, we had the usual, I think it's Rule 37 pre-trial conference. We've all been to them. It was a complete waste of time. We went through the motions so that we can come out with a signed minute. The minutes, by the way, were drafted out of an office precedent, and it was of no use at all. We've changed that now, and I'll tell you what the changes are and how to comply with them. Then there are directives outside of the rules regarding discovery, containment of issues, and expert witnesses. These are all different depending on which court you go to. There are some courts in the country that are so quiet, they have hardly any work, so they don't really need practice directives. But they will still have some directives which you have to be familiar with. The problem is if you fail to comply with directives, it just results in costly postponements, and you don't want that. I told you we need a non-adversarial approach. South African practitioners are extremely adversarial. There's no doubt about that. I mean, it starts with the notice, with the correspondence. Even the letters are adversarial. All kinds of dire consequences are threatened in letters. And you start off by creating a fight. And then this just continues all the way to trial. And very little gets done. And we all know that the greatest criticism of our court system is that cases take too long and it costs too much money. And the culprits there are the attorneys and advocates, the lawyers. They are the culprits. The lawyers are the cause of long delays and high costs. So how did courts around the world deal with it? They did it by introducing case management. Now, it happens in two ways. In most of the Commonwealth countries, there is a case manager appointed who is in the court building and manages the files. In our country, and also in those countries that use the inquisitorial system, the case management is carried out by judges. Now, what is behind case management? You might want to ask. It's not, obviously it's to reduce delays and costs, and so that members of the public can resolve their disputes quickly and cheaply. That's the whole idea. So how do you do that? Studies were carried out all over the world, and they all came up with the same answer. You don't have to manage the case, just manage the lawyers. That's what case management is about. It's about managing you. So you don't end up in court using scarce resources when it is unnecessary. In other words, go to court only when it's necessary and use the non-adversarial options where you can. Now, what we've done here in this country, it took us a very long time. It took the rules board years and years before they finally came up with Rule 41A. And that came out last year. The high courts discourage needless adversarialism. I mean, let's take a simple example. A defendant wants plaintiff to discover a document. They believe the plaintiff is in possession. Plaintiff ignores the letter. They're waiting for an interlocutory application, an application to compel. They will then cause the defendant to file a notice of motion and an affidavit. They will oppose it. They'll file an answering affidavit. Then there'll be a replying affidavit. Then the matter will be argued in the opposed court. They would have spent 150,000 rand. I mean, that's shocking. That's what we did. All it required is for the attorneys to sit together and say, let's talk about this. What document do you need? Tell us why it's relevant. And if we've got it, we'll give you a copy. Now you go to court, in the opposed court, the judge now hears this thing, has to write a judgment. There's a cost order. It's just nonsensical. One of the things we did with case management, And it has been very effectively done in Europe, in the UK, in the United States. They got rid of all the interlocutory applications from the motion role. I mean, go and look at the motion role in Joburg and in Pretoria or Western Cape. It's full of interlocutory applications, and they don't advance the case. All interlocutory applications do is that they generate costs and they waste a lot of time. So we case managed all of those things out. So if you have a dispute over discovery, go and talk to the case manager. The case manager will hear both sides and he'll make a ruling. It takes 15 minutes in chambers and it'll be done. What we introduced now is what we call court annexed ADR. In other words, an alternative to an adversarial hearing is made available in the court system. It took us a long time, but eventually we got Rule 41A. Practitioners are now expected to cooperate, to resolve disputes quickly and cheaply. And remember, it's in the best interest of the client. I'll tell you something that I noticed about lawyers, those who specialize in litigation. They have the biggest egos I've ever come across. It's about them. They are the main actors. It's all about them. Well, stop it. It's about the client. What clients want is to resolve the dispute quickly and cheaply. Clients don't want you to put up a huge fight that's going to take 6 years to resolve and cost a fortune. That's not on. Our courts will punish you for that. In fact, there's a very good decision you should read. Brownlee versus Brownlee. It's a decision of the Gauteng local division. And you can tell from the name it was a divorce. What happened there is that the parties went to court. Here's some advice for you. If you have a divorce, you are heading for trouble if you go to court. Divorces, especially disputes around custody of minor children, do not belong in an adversarial trial. We have some rules around it, but the approach now is keep it out of court. There are now mediation facilities available, and the attorneys are encouraged to settle. But Brownlee was a typical case, and I've seen many of those in my time on the bench. The parties don't settle, not because they don't want to settle. The trouble is caused by the attorneys. The attorneys won't give an inch. They want to go to court, and fees are generated all over the place, and the poor couple are left as hapless victims of this. Now, Brownlee is one such case. What happened there, the parties insisted they had to go to trial. They were allocated a judge. The judge took one look at this and realized that the couple were not the ones who were refusing to settle. It was the attorneys. The judge managed to confirm this. The couple, when they were given an opportunity, settled the matter easily. The judge then set about punishing the lawyers. Costs were disallowed, and the lawyers were disciplined. Now, you don't want that to happen to you. So we've got Rule 41A. The first thing I want to say about 41A is that it is intended that practitioners should actually comply with it. The problem with practitioners is that when there's a rule to be complied with, then they merely comply. What happens is someone in the firm drafts a precedent, which then complies with the rule, and then you just file it. You're not applying your mind to the purpose of the rule. And that's what you have to do. Actual compliance, not mere compliance. The first thing you will see in 41A is the definition of dispute, the subject matter of litigation between parties or an aspect thereof. Now, this applies to actions and it applies to applications. It's a very wide definition. There are certain disputes where judges will focus and will insist on compliance with the rule. Now, family law is one of them. I can assure you now, if you go to court with a divorce matter and you did not comply with 41A, the judge is not going to hear it. The judge will send you back to comply with 41A. In this division here, well, in this province, you will not even get a hearing. So it's universally accepted that family law should be kept out of adversarial courts. But the culprits, as I say, it's not the clients, it's the adversarial practitioner. And they all hide behind this rubric of, well, those were my instructions, my lord. And they think they'll get away with it. They did in the past, but not anymore. So the first prize is to settle the whole dispute through mediation. The rule requires the parties to set, but let's assume you can't settle the whole matter. Then at least the parties can settle some of the issues, if not all of them. If mediation can result in narrowing the triable issues, then the rule served its purpose. And now, you will also find that in pre-trial conferences and in case conferences with a judicial case manager, you will have to get into the habit of agreeing on what the issue is that requires a trial. And it has to be clearly defined. And I'll deal with that in more detail later. Now, the rule applies to every new action or application. You have to send a notice to the other side, whether you are plaintiff, defendant, applicant, or respondent, calling on them to indicate in writing whether such party agrees to or opposes referral of the dispute to mediation. Now remember, if you oppose, you are expected to give reasons for the opposition. So it's very easy to say, I oppose. It's like saying, I deny. But it's not so easy when you're called upon to give the reasons. So we recommend that when you take instructions to commence litigation, good lawyer will take instructions on the possibility of settlement and the possibility of a mediation. This is what is intended by the rule. There is a possibility that you could settle the dispute without launching proceedings. Now, I can tell you from experience, when a client walked into my office or my chambers and said, issue a summons, all I'm focused on is getting the summons to the sheriff. It has to be served as soon as possible because we have to show the other side. We want to go for them. Well, the last thing that I thought of, the last thing my attorney thought of was, hey, listen, guys, let's phone the attorney on the other side. Let's go and have a cup of coffee with him and see if we can't settle the matter. And never happens. Well, Rule 41A is going to force you to do that. Now, 41A3, it facilitates for the mediation process to be introduced or used at any other stage of the litigation. So, pleadings may have closed, you may have had your pre-trial conference, and there, someone might see an opening to mediate the case itself or a particular issue. Then the matter can, at that stage, be referred. The whole matter or even a single issue. Now, I cannot deal comprehensively with 41A here, but what I've done, I've given you in your notes a more comprehensive treatment of it. And you'll see there that I wrote that for LexisNexis. They have a practical guidance program, which is open for subscription to the profession. And I wrote it there. It's available there, but you have a copy of it in your notes. When you agree to mediate, it's essential for both parties to consider what issue is being referred. There must be a clear and shared understanding of the scope of the mediation. And the best thing you can do is to write it down. Don't think, oh, well, we know what the issues are. No, that's not good enough. Write it down and agree on it with your opponent. Otherwise, you are going to have a mediator who won't know what to do. The whole idea of mediation is for the mediator to have a good understanding of the case and to help the parties to settle. The mediator does not hear the matter, nor does the mediator make decisions. So the mediator needs to know this. Now, if you don't know what the issues are, how on earth can you go to a mediator? But you can also seek the guidance of the judge or case manager. If the matter has already commenced, then let's assume you're on the second day of trial. You can still seek leave of the court for a referral to mediation. And it might be a good time to settle or to define the issue. And you can enjoy the assistance of the judge or case manager. Parties agree to a referral. There are two things. The parties must present a joint signed minute of the agreement to refer to mediation. Without that, the judge is not going to agree. Prior to commencement of mediation, the parties must enter into an agreement to mediate. So you can see this is serious stuff. And there's a process to be followed. The rule does discourage rigid formality. The parties are expected to sign an agreement to mediate. You may include a definition of the issues and the scope of the mediation in the agreement. My advice is, if you agree to mediate, then define the issues or the scope in the agreement. There's much more about this in your notes that you have. Rule 41A6 is important. It is designed to encourage people to use mediation because all communications, oral or written documentation is treated as confidential and it cannot be used or admitted into evidence. This is the famous without prejudice communications. Well, here you have the rule which says it is without prejudice. So this encourages people to go into mediation. Now, I just want to say something on the side here. You will see that when practitioners draft particulars of claim, they try and say as little as possible. Or worse, they'll use a precedent and then they'll say nothing. Just use the precedent. There's this attitude that you shouldn't give too much away to the other side. Play your cards close to the chest. When we get to court, we'll play the trump card. Well, I'm sorry, that doesn't work anymore. You're not allowed to play games like that anymore. So litigation process, it's always been intended that it should be transparent. There should be no ambushing. There should be no clever points. You will see that the uniform rules as they stand advances that proposition. But the practitioners don't look at it that way. It's a game of poker. Well, that has to stop. You have to be more cooperative with your opponent. And you get those lawyers that will cooperate with no one and nothing. You can't talk to them. They won't answer their phones. They don't respond to emails. We've all come across those lawyers. They're a bloody nuisance, if you ask me. Well, we're getting rid of them. If you are one of those lawyers, then just stop it. Start cooperating with your opponent. And there's a remedy. If your opponent does not cooperate with you, put it in writing. I requested the following. You have refused to cooperate. We are now referring this to a case manager, a judicial case manager. Go and tell the judge, we cannot get cooperation. We need an admission of these facts. We need an admission of these documents. We want to settle the issues. The other side is not talking to us. Well, the judges have a way of dealing with that. And even the most difficult of attorneys don't like picking up a de bonis proprius cost order. And that's the weapon. Then there's this issue of costs. You know, whatever we do as lawyers, we have to apply our minds to the question of costs. Okay. 41A9 deals with it. Deals with fees of the mediator. Oh, when courts consider an order of costs, when concluding the action, the parties may refer the court
That's
to
why
the
I asked you what
notices.
options is it giving you once you log in?
Sorry, somebody's.
So even from your calendar site, you can't log in.
Sorry. Oh God.
Let me try to see if we can speak to our
I'm going
IT
to
guy
see
and
if I
we'll
can
get back to
sort
you.
this problem out.
Alrighty, thank you. Okay, bye.
All right. In order to encourage parties to refer issues to mediation, fees charged by mediators are meant to be reasonable. Now, I'll tell you how they've dealt with this. Most countries around the world have imposed tariffs for court annexed mediators. So you can't go and charge what you like. Most of you know that business has gone into arbitration and mediation. Senior counsel get appointed, senior attorneys get appointed as mediators or arbitrators.
I've got one of the delegates that's struggling to log on. I've tried anything and everything from my side to log him in onto Betty's webinar now. From restarting his PC and everything, and it's not working. One second.
I'm sorry about that. I'm in a studio at the Law Society, so things have to go wrong. Should have done this from my own chambers. Okay. So as I was saying, there's a tariff. You can't use a mediator if they're charging 30,000 a day. I mean, that's ridiculous. So the courts are now introducing tariffs. We don't have one yet, but it's coming. There will be a tariff. But if there's no tariff, then you go and negotiate, agree a reasonable fee. These people can't charge what they like. Now remember, always agree a fee. If it is unacceptable, find someone else, okay? Now, I've given you a reference to the LexisNexis civil procedure. I wrote the whole section on Rule 41A. My advice to you is, as part of your litigation strategy, this becomes extremely important. See that you comply, not merely comply, but use it in the interests of your client. That makes a good lawyer. Okay, now let's get to the interesting part here. One of the things we forget as lawyers, we get busy with pleadings and pre-trial procedures, and we're applying for dates and so on. You didn't consider the most important person in all of this. It's the judge. If you have to ultimately appear in court, you can only succeed if you persuade the judge to find in your favor. You will, as practicing lawyers, encounter judges in two roles now. Firstly, you'll encounter judges as judicial case managers. And secondly, you will encounter judges as presiding officers in your court. I will deal with the strategy involving both of those roles. As a practitioner, always think of the judge. When you draft particulars of claim, how will a judge read this? What is the judge going to get out of this? Will the judge understand it? Will the judge be able to work out the cause of action? Will the judge know what my client's case is? When I file a plea, will the judge understand that I do have a defense? Does the judge see my defense? Have I pleaded it in a manner that's persuasive? Think about the judge. Now, let's go inside a judge's head. What are judges looking for? Judges want to be able to read your pleadings and be able to work out the following things. There's three things. Firstly, what is the plaintiff's version of what actually happened? Now, it is important for judges to know what actually happened, what caused the trouble. If this was a contract, what happened between the parties that has now led to a court action? Was there a breach? Was there poor performance? What are the details of it? Now, we've all seen particulars of claim in accident cases where all the judge reads is that he failed to keep a proper lookout. Now, what on earth does that mean? Your client told you that the defendant's driver went through a red robot. Oh, no, but we're not going to plead that. We're going to use the office precedent to say he failed to keep a proper lookout. Now, I've read particulars of claim as a judge for many, many years. And one of the things that you struggle with is really working out what the case is about. Secondly, based on the facts of the plaintiff's version, what is the plaintiff's cause of action? Now, what is meant by cause of action? The definition of cause of action is, cause of action are the facts which give rise to a claim recognized in law. That's what it means. So don't go looking at the law. Law doesn't give you a cause of action. You first need a set of facts. Then the law comes along and says, if you can prove those facts, then the law says you're entitled to the following relief. If you can prove that the defendant committed the following breaches of the contract, the law now says you're entitled to cancel and claim damages. So that is what a judge is looking for. Then the judge wants to look at the defendant's version. Now, when a judge reads particulars of claim and finds that they are good and persuasive, the first thing the judge wants to see in a plea is, what's the defense? What's your answer? Now, if the judge is reading one bare denial after another, and you know that famous one, the allegations are denied as if specifically traversed and plaintiff is put to the proof thereof. It doesn't help the judge at all. It's nonsense. The judge wants to see what the defense is. And if you don't plead it, well, the judge must assume you don't have a defense. Now, when the judge reads pleadings, the judge will want to work out, what is the tribal issue? Why do they need a trial to resolve it? What is the issue? Now, if the pleadings are not clear, here's a warning. Be very careful about this. Lawyers get embarrassed by it daily in court. If you go to a pre-trial conference, you are supposed to agree on what the tribal issues are. There's a directive that says that. But what the attorneys and advocates did, they were playing it smart. So in the column of the pre-trial minute where it says the state the issues for trial, the attorneys wrote, refer to pleadings. Now that's very clever, eh? The pleadings, of course, don't tell you what the issues are. So now what the judges do, they say, define the issues between the parties and write it down. Put it in writing. In other words, don't refer to the pleadings, just write down what the issues are. Now, here's a good way to test your understanding of the case. After pleadings close and you see the discovered documents, you've read the expert summaries, sit down, take a piece of paper, write down what you think are the tribal issues. Now, let me assure you of one thing. That is easier said than done. It is not so easy to do. If you have a bad set of pleadings, it will be even more difficult thing to do. I'm going to show you how to do it. As I told you, both opposed and unopposed interlocutory applications are discouraged. These interlocutory disputes, these are disputes around process and procedure. They have very little or nothing to do with the substance of the dispute. We want to deal with that, dispose of it in chambers. What you should do as a practitioner, and you are expected to do this, if there's an interlocutory dispute, let's say it's over discovery, or the admission of a fact that is not material to the case, you are expected to go to your opponent first and say, can we agree on this? Most reasonable lawyers will apply their minds and they will agree. That is then minuted and the dispute is gone. But if you can't resolve the dispute, let's say you can't agree on whether or not a document is relevant or whether or not a document requires proof. It's simple. You don't have to go to court in the opposed court. Go to the case manager, put that as an item on your agenda, and ask for a ruling. That will be the end of it. Now, this thing about discovery, I say you apply your mind to discovery at an early stage. Now, my advice is when you're taking instructions, that's your first phase, you obtain all the facts there, right there. Then you obtain all the documents already before you issue the summons. Now, I know most people don't do this. They don't get all the information before issuing summons. They first issue the summons. Then, as they find more information, as they get documents, what happens? They keep amending the particulars of claim, or they keep amending the plea. Now, listen, amendments are the worst thing. And you know what's the worst thing about an amendment? It doesn't go away. Your pre-amended pleadings are still in the court file. They are not wiped up off the face of the earth. And do you know where it bites you? When your client is in the witness box. When your opponent says to your client, Mr. Smith, did you tell your attorney the following? And your opponent is reading from your amended particulars of claim. What do you think happens? Your client can't answer that question, not in the witness box. There's no right answer to that question. You end up discrediting your client. Whose fault is that? It's the lawyer's fault. So get all the facts and the documents up front before you start drafting the particulars. One of the things we did with discovery over the years is that we discovered the whole office file. I mean, everything got discovered, the whole works. So I've seen cases where I sat, and plaintiff's counsel stands up and says, may I hand up plaintiff's bundle? I get 4 lever arch files. Defendant's counsel, may I hand up defendant's bundles? 3 lever arch files. So I'm sitting with 7 lever arch files. The trial runs for 3 days. And then I realized I only used 2 pages out of 7 lever arch files. It is an abuse. We don't allow it anymore. It was nothing more than a fee-generating exercise. Now you only discover what is relevant to the issue, and then you must reach agreement on the admission of the documents. I'll deal with that as well in more detail. You must expect a judge at an early stage to expect you to articulate what your versions of the facts are, whether you're plaintiff or defendant. Now it starts firstly with your pleadings. The particulars must say what your version is. Your plea must say what your version is. Then, when pleadings close and it becomes clear what the issues are, the next step is get ready to make admissions of fact. A judge will actively assist the parties to confine and define the tribal issues. And this is more likely to happen where the parties filed vague, precedent-based pleadings. Now, you know what I'm talking about. Go to your office files, open the pleadings, read it. It will be your pleadings, but ask yourself, what's the issue? What's the case about? If a judge reads this, what will the judge think? If there's vagueness, if it is not clear what your cause of action is, if the issues don't come out, then there's something wrong. Then you have to fix it. In a trial, and this happens in every trial, the judge must first make a finding of fact before they apply the law. So you must be alive to what findings of fact you want the judge to make. So it starts with the cause of action. What are the issues? What are the facts that you have to present in order to persuade the judge? And that we'll deal with in more detail. Finally, judges do not hesitate to punish litigants who do not cooperate. And this includes cost orders against practitioners. Now I want you to go and read Rule 37.9a. Some of you might be familiar with 37.9a, but that's the rule. It's been around a long time, but judges never used it. But now they are using it. It's simply, in simple terms, it says, if practitioners don't cooperate with one another, a judge can make an order of costs against the practitioner personally. And I've seen many cases where that has happened. So this is a quote from a book that I was reading called How Judges Make Decisions. It says there that a judge engages with real people and real conflict, where invariably he is faced with a choice between opposing parties, and he has to do the best he can with the evidence available, according to the burden and standard of proof. Now, that's a very important statement. I want you to underline it. I want you to analyze it, because you will see that the rest of this presentation is going to be talking to this. You cannot win a case or succeed in persuading a judge if you don't have, firstly, the available evidence. The evidence must be available to you. That's first. And second, it's how you present that evidence to a judge. And thirdly, you do so in order to satisfy the burden of proof or the onus of proof. on a standard of proof being a balance of probabilities. That is what you are supposed to do. Your job is to assist the judge to find that your client discharged that burden of proof. That's what it's about in a nutshell. If you can't do this, well, don't go to court. You are going to pick up a cost order. That's all you're going to get out of the judge. Now, let's focus a little bit on the facts. A judge's reasoning and conclusion must be practical, suit the facts as found, and provide an effective, workable remedy to the winner. Now, one of the things judges will do is they don't just resolve issues. They then have to apply their minds to the remedy. The remedy must be a workable remedy. In other words, it must be capable of being executed. It must be capable of being satisfied by the other side. Now, judges are concerned about that. Many of you are aware that judges will insist on the parties presenting draft orders in court. And a very useful thing is to get hold of the Gauteng practice manual, where it sets out all of the different draft orders you can get in this division. Now, a judge cannot be expected to come to a conclusion without first informing herself of the facts and the law. When a judge sits in a trial, or when a judge is reading 3 sets of affidavits, the judge is informing himself or herself of the facts. When they've satisfied themselves as to the facts, they have to then make a finding of fact where there is a dispute of fact. Then they apply the law. It doesn't work the other way around. So let's go to the beginning. I told you what the judge's job is, and what you have to do as a successful practitioner is to present your case, your client's case, in such a way that the judge says, I like that. I think they've just discharged the onus. I'm going to give them the relief that they want. That's what you have to do. Well, before you start, find out what are the material facts of your client's case. In other words, what are the facts that gave rise to the dispute in the first place? Now, I'm warning you, do not put pen to paper without knowing that. Occasionally, there's some urgency, like in an urgent application, or your client's case is about to prescribe in 2 days. You have to get the papers out quickly. But even in those circumstances, you have to work long hours through the night, get the facts first before you put pen to paper. Because once you put pen to paper and you got it wrong, the consequences can be disastrous. Now, the next question you have to ask yourself, and it's a good idea to ask this question in the presence of client. If I can prove all those facts that you say caused the trouble, what are the remedies that your client can practically obtain? Now, remember, winning a case is one thing, but obtaining a remedy that satisfies your client's requirements is a completely other thing. Practically, to obtain a remedy that is practical means it is a remedy that can be satisfied. Don't get a remedy that your opponent cannot satisfy. It just doesn't work. Your client has not achieved anything. And I end this slide with a message for any litigating lawyer, any lawyer in dispute resolution. There's only one rule: obtain the available facts first. There's no substitute for that. It's facts first, okay? I don't want to sound like a bad president, but that's what you do. Now, where does it go wrong? It goes wrong because practitioners are in a hurry to issue the summons. I've said they're in a hurry to file a plea. That's wrong. I've never found an attorney who was in a hurry to file a plea. You have to compel, you have to file a notice of bar, then they'll file a plea, which is a bare denial. So when you issue a summons and you're in a hurry, you have not obtained all the facts, you have not seen all the material documents, you will issue your summons out of your favorite office precedent. There's no doubt about that, because you are not capable of drafting particulars of claim because you don't know the facts yet. And if you put in a plea that is a bare denial, well, you're going nowhere. You are not going to succeed. A case managing judge will haul you up and say, I've read your plea, it's a bare denial, it is excipiable, I will give you 7 days to amend it, otherwise I'm going to suggest you talk settlement. That's what a good judge will say. You will be of no assistance to the judge with vague pleadings and bare denials. And equally, if you are of no assistance to the judge, you don't belong in a courtroom. So what is it that makes a judge sit up and listen? Reading pleadings that make sense, that disclose a cause of action or a defense based on the peculiar facts of your client's case, not based on a general precedent. It's like in a divorce case where you say the cause of the breakdown was a failure to communicate. Who the hell knows what that means? Or worse, there was no love and affection. Does anybody know what that means? Well, certainly I haven't met a judge who knew what that means. A compelling version of what actually happened is what a judge wants to see. And that brings me to what is called your case concept. What is a case concept? Case concept is your client's version of what actually happened. You need to come up with a version that is consistent and it supports your client's cause of action or defense. That is the most important strategy, and a judge will look for it the minute he casts his eyes on your pleadings. An adversarial judge is not a seeker after truth. And that's a fact. Inquisitorial judges are seekers after the truth. That's what they do. An adversarial judge has no powers to go out and look for the truth. That judge has to sit in court as a neutral trier of fact and has to make a decision based on what the parties present. Now you can see how important this is. This judge cannot find in your favor if you did not present the judge with facts that he's persuaded that your version of what happened is acceptable. A judge may even say that I heard a witness, Mr. Smith. When a judge says, I was impressed with Mr. Smith. I find that he told the truth and I accept his version. Now, you know what that means? It doesn't mean that Mr. Smith actually told the truth. In fact, he could have lied. What it means is that the judge listened to the version, was able to find that it is plausible, that in the circumstances of the case, it is probable, the witness is credible. The judge then says, I am persuaded that he told the truth. What the judge is actually saying is that for purposes of this hearing, I find that he told the truth. The judge is not saying he is telling the truth. He is saying, for the purpose of this hearing, I find that it is the truth. The judge is saying, I find that that is what actually happened. If you cannot do that, don't go to court. And I will show you how you can present your case so that the judge accepts your version of the facts. Now, the evidence or the facts that you present has to be relevant to the judge or to the issues before the judge. Now, here's one thing that is guaranteed to irritate judges. When you present facts, evidence that is not relevant, you are wasting valuable court time. How often have you seen in trials, the judge stops the lawyer and says, Mr. Peter, what's the relevance of this witness? Or you'll hear judges say, Mr. Peter, is there a point in this somewhere? The judge can't see the relevance. If you entertain the judge with irrelevant nonsense, well, the judge will entertain you with a cost order. The facts must also be admissible in its form. Now, we have this thing called the rules of evidence. You're not supposed to ignore it. You have to comply with it. So the first rule is it must be relevant, then it must be admissible in its form. And right there is what we call the golden rule of evidence. All relevant evidence is admissible unless excluded by a rule. Some of you might remember that from university. All it means is that the judge must find your witness's evidence to be relevant to an issue. In other words, relevance means the evidence must assist the judge to resolve the dispute. That's what it means. But relevance is not enough. The evidence must still be admissible in its form. You can easily have a witness give relevant evidence, and then the judge says, but how do you know that? And the witness says, well, I heard it from my friend John. He told me all about it. Well, it's hearsay. And unless the friend John is being called as the next witness, the judge will throw it out. And then finally, this is not something you will see in any textbook on evidence. The version presented by the witness, or the overall version presented by the plaintiff or defendant, must be probable in relation to the facts of the case. Now, notice I didn't say must be true, because it's not about the truth. Judges don't know what the truth is. But what judges do know, and what all good lawyers know, is that they can look at the circumstances of the case and can work out quite easily that party A's version is more probable and more likely to have happened than party B's version. And I will be showing you how to test that as we go along. All right. Where do you get the facts from? There are a number of sources: statements from client, statements from witnesses, documentation, photographs of the scenes where relevant, and identifying expert witnesses. Now, there are 5 things on the screen. You have to obtain all of that before you issue the summons. You do it now. That's part of the instructions. Now, there are very few practitioners who obtain witness statements at this stage. They think, it's not necessary. We'll use Ambler and we'll send out the summons, or we'll file a bare denial. Well, the trial is a long way away. We'll find the witnesses at that stage. Well, that's a recipe for failure. And under a case management regime, you will not be allowed to do that anymore. So you have to get all of these things now. Let's look at the method. Establish what your client's version is. Establish that your client's version is likely to have happened. And there's a useful test. Actually, we all do it. We do it subconsciously. When the client gives you a set of facts, very often you're sitting there thinking, oh no, I don't believe this. Oh no, this is nonsense. But you don't tell your client what you're thinking. You are then going to do the following. You'd say, well, you know what? I think it's nonsense, but those are my instructions. I'll take down the statement. Well, you're a bad lawyer if you do that. Now, here, there is a way that lawyers use, a method that lawyers use to test a client's version. And judges use it all the time. And I'm warning you, never forget this. Take your client's version and ask yourself, do the undisputed facts between the parties support your client's version, or do those facts support your opponent's version? If the undisputed facts do not support your client's version, it's very likely that your client's version will be found to be improbable, because it's one way to test it. And I'll deal with the undisputed facts later, and I'll talk to you about the Plascon test. But if you sit down after your client gave you the story, it's very easy for you to work out what are those facts that are not in dispute or not likely to be disputed. Then take the disputed version and test it against a framework of the undisputed facts. If it's not supported, you've got a problem. So use that test. It actually works well. But very often it's quite easy to do, because clients will give you a version and you know immediately this is nonsense. Now, for God's sake, don't proceed on that version. Now, I know it's difficult to say to client, hey, listen, you're a bloody liar, get out of my office. You don't want that. You want to assist this person. After all, you'll be charging a fee. So say to them that, I've heard your story. Now, here are my reasons why I think a judge won't accept it. That's a nice way of saying to your client, you're a bloody liar, is to say, listen, I don't think a judge will be persuaded by it. And you tell them why. Look at these undisputed facts. They don't support what you're saying. Okay, so deal with that at an early stage. You then have to establish if the supporting evidence is from reliable witnesses. You need to look at corroboration and credibility. And at this early stage, you must secure the presence of witnesses for a trial date. In other words, identify who your witnesses are, get their contact details, keep in touch with them. I can tell you many a good case fell by the wayside because when the parties get to court, the witness doesn't turn up, or the witness has just disappeared. Now, here's an important strategy for two reasons. One, it helps you to understand your own case. It helps you with testing the probabilities of your case. And that is sequencing. Chronological sequencing is vital. It is part of your strategy. Those of you who are running cases without establishing a chronological sequence of the facts, without establishing a chronological sequence in the bundle of documents you want to use, you are heading for trouble. You must establish a chronology in respect of every witness you call. Witness A, witness B, witness C. They each give you a version. Never take down that version unless you have sequenced them first. Lay people do not sequence their facts. They tell you a story. It may have a beginning, then it's gone somewhere, and it comes back to the middle, and then it goes back to the start, and eventually you don't know where it ends. But it's a version. Your job is to listen to the version and then say, listen, let's take it step by step from the beginning to the end. I'm going to write down your statement, and we're going to do it sequentially, step by step. That is very important. Now, just to support my point, if you think chronology is not so important, go and look at the rules in the SCA, Constitutional Court, Gauteng Provincial Division. In the SCA and the Constitutional Court, it is compulsory to file what is called a chronology document, where you set out in a sequence what the material facts are between the parties. The same applies in the motion court in Gauteng. When you go to trial, you must start your chronology document when you're taking instructions and develop it as you go along. As pleadings close, as you get trial certification, because one of the things that works in a trial is for you to have a chronology document in front of you. And I will show you that it is a very useful thing in opening statement to say to the judge, my lord, may I hand up a chronology document to assist your lordship? I've done it myself. I've seen it work in court. What the judge does, keeps that chronology document right there next to his file. And as the witnesses testify, the judge is looking at the chronology. Now, one of the things chronology helps you with, it helps you to work out if your client's version is probable. If the chronology or the sequence does not make sense, it's like criminal cases. Some of you may have had experience of criminal cases. The most popular defense in this country is this thing called an alibi. It wasn't me. That's the old story. Well, I've seen many practitioners get embarrassed because they did no sequencing, and when the judge says, but this doesn't make sense sequentially, and finds that your alibi is false, then it's too late. But with commercial disputes, civil trials, chronologies are extremely important. When you're leading a witness in chief, for example, your own witness, you should have a chronology of that witness's version in front of you, so that as you lead the witness, you lead according to that sequence. It helps you to control the witness, and it helps the witness. The witness knows where to go next because you wrote their version down in the sequence as you want it. Documents, I cannot stress, you will be a fool if you merely review documents as your client brings them to you. Clients don't know about sequencing. They bring you a lever arch file or a box full of documents. You put them on your desk and you start reviewing them. Bad strategy. First sequence them. Oldest one on the top, latest one at the bottom. Then start reviewing them. Because if you merely review documents in any particular order without sequencing, you are going to make a mistake, especially those of you who are in commercial practices. Commercial clients generate documents, hundreds and thousands of pages of documents. The heart of the case will be in those documents. One of the most persuasive things in court is when a witness testifies and is able to produce a contemporary document to support it. Judges love it, they believe it, it's highly persuasive. So don't underestimate that. When you've got all the facts and the documents, you must prepare your first chronology document. Set out in a sequence the material facts of your version. The document will be updated and amended as the matter unfolds, and eventually, this is the document you will present in court. Now, whether you're in an application or an action, you are to produce a chronology document. Must be done. Because when you get to court, day one, be it trial or application, you will need that chronology document. If you're in the opposed motion court, you will have to file the chronology document. Now, those courts where there's no requirement for a chronology document, well, you don't need to be compelled to file one. You should file one anyway. Why? Because it helps the judge. That's the whole idea of a chronology document. It helps the judge. And the reason why the SCA and the Constitutional Court want chronology documents is because they know, as judges, they can be easily misdirected if they don't have a chronology document. And it's happened. I've seen serious mistakes being made in the High Court by the judge because there was no chronology document, and the evidence was presented in such a way that the judge didn't realize that the chronology did not make sense. A simple thing like not being able to work out that a document was backdated, and that changes the whole case. So you need to prepare the chronology documents right from the start. Now, very much part of this is this thing called the case concept. You know, it is very surprising that practitioners can go to court and not actually know what the version is. They hear it for the first time when client is giving evidence in chief. And very often, the evidence is something they are coming across for the first time. It's not in the pleadings, and they're immediately in trouble. It is a crucial step because the case concept will tell you how the case must develop through each of the 4 phases. When you get to the trial, these days, when you get to the trial, the issues will already be defined by a case manager if you didn't do it yourself. The issues will be confined. You will already know who your witnesses should be. But all of this is based on a consistent version that you developed from drafting your particulars of claim or your plea all the way through pre-trial proceedings and then to the trial. You develop the case concept from the facts and the supporting evidence you gathered. From this, you have to formulate a cohesive and persuasive story to convince the judge this is a true version of the events. Right, let me tell you something very basic here. The judge is a human being. When the judge sits out in court, the judge is saying, is thinking, what's your story? Tell me your story. I want to hear what happened to you. I want to hear what caused the trouble. That's what they want to know. Now, if you don't know what that story is, how on earth are you going to present it to the judge? You know, if you can stand up in opening statement and tell the judge very briefly, my lord, this is my client's story, and we will prove the following facts. I will be calling these witnesses to assist your lordship. You've got the judge on your side. You want to grab the judge's attention. But now if a judge walks into court, read your rubbish pleadings, doesn't know what the version is, the judge is now going to try and squeeze you in opening statement to answer all the questions. Well, I can tell you that's not a very comfortable place to be, especially if you don't know what the case concept is. But the first process, when you've got the facts, you have to work out the client's cause of action. Now, you'll see that I've emphasized that this is easily one of the most difficult tasks for many practitioners. What this means is your client tells you the story. Your client gives you supporting witnesses. Your client gives you a set of documents. So what you're sitting with is a whole lot of fact. What you now have to do is firstly work out what is my cause of action. On these facts, is my case in contract or is it delict? Or is it a case based on statute? Is this common law or is it statutory law? What are the material facts? If I can prove them, what does the law say is my remedy? Then comes the second difficult part, is you have to now plead it in your particulars of claim or in a founding affidavit. Now, this is not a very easy thing to do, but if you start drafting without getting the facts first, if you use the office precedent, well, you're a bad lawyer and you get a bad outcome and you'll deserve it. Now, here's a warning. Again, when you encounter a set of facts or a version that seems implausible, when I say implausible, it means you don't believe it yourself. Just stop. Don't carry on. Don't say those are my instructions. The judge is going to give you a problem. You know, I've come across cases where the judge is listening to this evidence and finds it to be entirely implausible. In fact, the judge thinks it's nonsense. The judge looks at the counsel and says, listen, do you really expect me to believe this nonsense? What do you think the answer is? The counsel looks up and says, well, my lord, those were my instructions. Mostly, they got away with it. Not anymore. Because the next question a judge asks is, are you not an officer of the court? Don't you know that you shouldn't be coming here with a load of nonsense? It's an abuse of process. And then you're going to be embarrassed. Right, let's, what I'm going to do now, it's 1:30. Can we take a 5-minute break? 5 minutes, and then I'll come back and deal with the cause of action. Right, 5-minute break. Oh, those people are not ready yet.
Okay. There you are. Okay, you can sit.
Who's MA? What's this? Steph? Steph? What, Steph? What's this MA on my screen?
That's a person that we can just minimize it for you. There you are.
Can I go?
You can go.
Can I go? Okay, I hope everyone's back. The difficult thing with webinars is you just never know who's there and who's not there. Yeah, and I also miss the socializing during tea breaks and lunch. Oh, who knows when we'll get back to normal again. Right. Let's start with this cause of action. One of my biggest problems is that practitioners don't work out the correct cause of action. And then, even if they do work it out, then they plead it incorrectly. As for the plea, the rules tell you what to do. The rules tell you that you must admit, deny, confess, and avoid. And you must state your facts. That doesn't get done. And I'm going to show you how to do this more effectively. But there are also uniform rules there that still apply. If you don't comply with the uniform rules, your particulars of claim will become excipiable. Someone might file a notice to remove cause of complaint. It could even end up as an exception. The problem begins when the practitioner fails to get the cause of action right at the beginning. And how does that happen? Because you didn't get the facts. You got some facts or a rudimentary knowledge of the facts, and then you decided to start drafting. That's wrong. You'll get into trouble. So if you define a cause of action, it's the facts that the law recognizes as giving you a claim. So cause of action is not about the law, it's about the facts. So how do you go about formulating the cause of action from a set of facts? Now that's the hard part. Okay, I'm going to take you through this step by step. Now, some of you might have already got my book. It's called Practical Drafting Skills. That book actually tells you how to do this step by step. If you haven't got the book yet, get it. I know that many attorneys are using it on a daily basis because what it does, it frees you from precedents. And that should be a very important goal for you, that you must be one of those lawyers that never needs a precedent. You know, you need precedents when you're drafting commercial documents, but then you must use precedents. But for litigation, for drafting pleadings and affidavits, you cannot use precedents. You are going to be misdirected when you do that. You know, and attorneys and advocates as well. I've seen them make the silliest of mistakes. I've seen where quite obviously a precedent was used because the name of the plaintiff from the precedent was repeated. So this particular set of claims has got, the plaintiff has two different names. And that's the kind of stupidity you see. And can you imagine the impression that makes on the judge? So just don't do that. By now, you've gathered all the available facts. That includes all the available documents. If you're in commercial dispute resolution, documents are absolutely vital. Now, this is how you do it. Begin by writing down, using numbered paragraphs, the material facts of your case. So what you've got a statement from your client, you have statements from your witnesses, you have a chronology document. Now, write down what you consider to be the material facts or the main facts that gave rise to your client's claim. Just write it down. Don't worry about style. Don't worry about numbering and so on. Just paragraphs, number them, and write it in your own words. Don't try and take it directly out of the statements. Write it in your own words. Now, once you have recorded the material facts, now write down what were the consequences to your client. Because this incident happened or this breach occurred, what happened to your client? Did his business suffer? Did he suffer personal injury? What is it? Again, don't be lazy, write it down. Now, I'm just going to give you a practical piece of advice here. And I can assure you it works. I kept emphasizing, write it down. There's a good reason for that. When you write something, be it on a piece of paper with an old-fashioned pen, or you open a file on your computer and you start writing. When you start writing, that's when you apply your mind. There's nothing like writing to force you to apply your mind, because you cannot write without thinking. The only way you can write without thinking is if you use a precedent. Now you know why a precedent doesn't work. It's because you're not thinking, you're copying and pasting. But when you write anything straight out of your head, you are forced to think. That's when all kinds of problems emerge or answers appear while you are writing. Writing is a wonderful discipline, and that's what lawyers do. We are people who earn a living from writing. Once you've written this out, you will understand the context of the matter. In other words, you'll now begin to see what happened, and you'll be able to see what area of the law is involved. For instance, you wrote down that the parties entered into a contract. The contract was to supply machinery. The machine broke. It didn't function. What happened because of that? Your client lost a lot of business. You can see immediately that this is a claim in contract. The cause of action will be in contract. So immediately you can confine your research to the law of contract. Now, once you read the law of contract and you look at your facts, you can work out that if I can prove those facts, this is what the law says I'm entitled to. And that is how you go about working out your cause of action. Your client says you went to a hospital and suffered as a result of incompetent treatment by the staff, as a result of which terrible things are happening. You immediately know that this particular case is a claim in delict, but it's also a claim in contract. There was a contract with the hospital, but there's also the negligence in the way your client was treated. So now you have to read the law of contract and the law of dealing. And then you're going to plead your causes of action in the alternative. Now here's a tip. If you have a set of facts that can support more than one cause of action, don't decide, well, I'll choose one and not the other. The better option is for you to plead both in the alternative. So for example, you plead a case in contract, then you will go alternatively case in dealing, okay? The purpose of your particulars must not be forgotten. You are telling the defendant what is being demanded of him and why are you entitled to make that demand. The next step is to research the law. Find out what the law says is the remedy. If there is a remedy, should you be able to prove the material facts of your case? Now remember, it's the law that tells you what your remedy is. That's the function of the law. But before you get to the remedy, the law will say, what are your facts? If you can prove those facts, then you can have the following remedy. So the moral of the story is, before you go running off to the law, first get the facts. That is the rule. The one thing you should never do as a good lawyer, never go and read the law if you don't know the facts of your case. The one way to guarantee that you will misdirect yourself is if you go and read the law without knowing all of the facts of your case. You will make a mistake. Now, the law will tell you something else. The law will also tell you what are the material facts that you require for your chosen cause of action. These are what we call the elements or ingredients of the cause of action. In simple terms, the material facts that you need to prove in order to succeed. When you now go back to the list of facts that you wrote down, your material facts, you'll be able to mark off those facts that you need to prove in order to succeed. And it will be those facts that you will plead in your particulars of claim. Now, at this point, you have done two things. You have two lists. Firstly, a list of your client's material facts, including the events. And secondly, you'll have a list of the essential elements that the law tells you for that particular cause of action. Now, I'll tell you that there's a very useful book that helps you with these so-called essential elements. Let me just digress a little bit when it comes to researching the law. In this country, we use the common law system. In other words, our law is developed through the courts. Unlike other countries like Germany, or well, most of the European countries, where their law is codified. So there's a code. We don't use codes. Some of our law, like company law and tax, is codified, but we're a common law country. We also use the system of binding precedent, or stare decisis, as we old lawyers call it. What that means is the law is what the courts say is the law. So, as a good practitioner, if you want to know what the law is, don't go and read textbooks. Read the cases. I'll tell you why textbooks are useful. Textbooks are useful for two things. Now remember, what's in a textbook is not binding on a judge. It may not even be persuasive, because a judge can treat that as the opinion of an author. But a judge is bound by a decision of a higher or equivalent court. And that is the system of binding precedent. What you need as a lawyer is to find a decision on that particular cause of action, the most recent decision of the highest court. That's all you need. One case. You don't need 50 cases. Now, the problem is, if you do general research, you start with a textbook. Textbooks are also good for helping you establish the general principles of the area of law you are looking at. It's very important to know that. But the textbooks are also good for telling you or giving you case references. What you do then is you go to the cases referred in the textbook. And then comes a very crucial step. Whenever you read a decision, it doesn't matter which division of the High Court, always check the annotations. Because the annotations will tell you if that decision was followed and applied, and if it is good law. The annotations will also tell you that that decision was set aside by a higher court, which means it's no longer good law. The most embarrassing thing is for you to go to court, rely on a case, only to find that it was set aside by the SCA 2 months ago. Well, you can avoid that by using annotations. The electronic law reports supplied by JUTA and LexisNexis have annotations. And it's very easy. You can simply click on annotations and it tells you the whole history of that judgment. And the best way to find the most recent decision of the highest court is in the annotations. The annotations will take you there. For instance, in the annotations, it will say applied, and it will give you the citation of an SCA decision or a constitutional court decision or a full bench decision. And you know that's the case you want. The only problem is these electronic annotations, which are absolutely vital if you're a busy practitioner, is only available to subscription electronic law reports. You also have hard copy annotations. Some of you may be familiar with the Nota Up. That gives you the annotations, but you know, it's hard copy. No one buys those things anymore. We rely on electronic annotations. Many practitioners rely on SAFLI for their judgments. The only problem with SAFLI, I mean, it's free, so you can't complain, is that there are no annotations there. And it's a very dangerous enterprise to rely on cases you picked up on SAFLI without checking the annotations. Even if it's an SCA decision, the SCA has a habit of finding that it was wrong and then set aside the decision. The Constitutional Court does the same thing. How would you know? Look at the annotations. Okay. So when you have these two lists that you wrote, your client's material facts and the elements of your cause of action. Now, let me deal with that elements for a moment. Most of you are familiar with AMBLR. Now, AMBLR is actually not a set of precedents. If you simply copied and pasted out of AMBLR, you will find that your particulars of claim or plea will be excipiable. What AMBLA is really good for, and that's what it's supposed to be used for, it takes each cause of action, where it could be suretyship, lease, building contract, defamation, personal injury, whatever. It deals with a whole lot of causes of action. It takes each cause of action and merely gives you the material facts that you need to plead, or the elements of that cause of action. What you have to do is to see if you can satisfy those requirements with your facts. Then you plead not what's in AMBLA, but you plead your facts. That will turn out into good particulars of claim. Now, this is not easy to do if you're inexperienced, but here's another practical tip. You will never learn if you don't try. It is nonsense that some people can and some people can't. All lawyers can turn into really good draftsmen, or should I say draftspeople? I don't know. I get confused with this gender nonsense. You can turn yourself into really skillful drafters of particulars of claim and pleadings and affidavits and heads of argument. You need to get practice. It's like everything else in life. The more you practice, the better you get at it. Nobody is born to be brilliant. You have to learn to be brilliant, and you can. What I'm giving you are the steps that you have to take. Now, if you don't do this on your own, you're never going to come right. Now, I'll tell you, in the past, we had this luxury of outsourcing work. So you have to issue summons, you need to draft particulars, you brief counsel, or you send it to another attorney. They draft something and send it to you. You end up losing 2/3 of your fees, and then it may not be right. Now, you can't practice like that. And as you know, with the Legal Practice Act, the profession has been opened up. So you are now competing with a lot more people than you did in the past. So if you keep outsourcing your work, you'll make yourself redundant. You'll be sequestrated, in other words. So you need to learn to do this on your own. And the trick is to keep the fees in the firm, not to give 2/3 of it away in outsourcing the work. Right. Let's test this further. Read through what you have written. Ask the following questions. Can my client's facts be sufficient to satisfy the essential elements of the cause of action? Remember, I told you that's what AMBLA gives you. What you have to do is look at your set of facts. Now you've written them down. Can I use that to satisfy this requirement? If not, then there's a gap in your version. You need further instructions. So the question is, if I prove those facts, what does the law say is the remedy? Now, what AMBLA also does is it gives you the remedy that you can claim. And another useful thing is that AMBLA also refers you to the case law. But I also find that the case law can be a bit outdated. So how do you solve that problem? Call up that case on your electronic law reports, go to the annotations, and it's all there. The good thing about annotations is that it gets you to the case you want quickly. And that's the trick. You're not at university where you can do research for weeks and weeks on end and then get an extension for your assignment at the end of that. No, now you are in the real world. Time means money. You don't have the luxury of spending hours on end on legal research. It's simple. Your client's not going to pay for those hours. And you can't bill for those hours. And your partners are going to be wondering what you did all day because you're not writing fees. So if you're a sole practitioner or an advocate, you still have to write fees. You can't spend all day or 2 or 3 days looking for a judgment. Your client's not going to pay for it. So get annotations and learn how to use it. You'll be efficient, you'll be quick, and you'll financially will be far more better. Now, you've got the 2 lists of facts. So basically, you've got your first draft. Now, if you want to see a more detailed instruction on how to do this, and look, I'm not trying to sell you stuff here. I know I'm an Indian, I'm supposed to sell you something, but I'm not doing that. All I'm saying is get my book. It will show you how to draft without using precedents. It works with understanding, and it shows you how to practice the skill. Now, by now you probably worked out that this is not an area of the law for lazy people. This is the hard work. Now, one of the things I always tell lawyers, the very pinnacle of legal practice is the trial lawyer, okay? Nobody, have you ever seen a lawyer get his name into the newspapers because he's a conveyancer? Or even better, he's an administrator of estates. Who cares? But the trial lawyer, you're in the public eye. You are performing in a public space. These days, there's a good chance you'll even be on television, okay? Your mother-in-law will see you on TV. You'll be a star for the rest of the month, okay? Well, you can also make an ass of yourself. To be that top lawyer requires hard work and application, and you can get there. What this course is about is to give you those skills or tell you how to do that, but it can never turn you into a good lawyer. You have to turn yourself into a good lawyer. Okay, let's go to the particulars of claim. I'm stating the obvious first. If you get this wrong, well, you're in trouble before you even started. There's nothing worse than drafting particulars of claim, issue the summons, the sheriff serves it, and you charge your client for it, and not long thereafter, you receive an exception. I mean, that's just the worst. You want the matter to flow smoothly. You want the defendant to read your particulars and say, hey, maybe I should settle this matter. It needs to be effective. So your particulars of claim firstly sets out a cause of action based on the peculiar facts of your case. And then it sets out the material facts of your client's version. Never use a precedent. If you are acting for a defendant, you need to answer the substance of the plaintiff's claim. A bare denial is of no use to anyone. You need to set out a defense based on the facts of your client's version. Now, you've all read these particulars of these pleadings, where it's just bare denial after bare denial or a plea of no knowledge. When you finish reading a plea like that, what are you thinking? The only thing you're thinking is that this defendant does not have a defense and is wasting court resources. This is an abuse of process. Well, I got news for you. That's exactly what a judge is thinking. And then you have to apply your mind to the onus of proof and the duty to begin. They are two different things. The plaintiff will always bear the onus of proof. Plaintiff is the one who brings the action or application and must prove the case. When you start drafting particulars of claim, when you've got your first draft, a good idea is to ask a simple question. I've pleaded these facts. If my opponent does not admit them, can I prove them? Who will be my witnesses? Do I have witnesses? And what documents will I need? Or will I also need an expert to assist me? You need to ask those questions before you send out your particulars or your summons. What I'm saying to you is that when you ask the question, can I prove those facts? You are asking yourself, can I discharge the onus on me as plaintiff? That is very important, because if you can't discharge the onus, that onus of proving those material facts, then don't bother to issue your summons. You're going nowhere. You're going to waste costs. And then there's the question of the duty to begin. Usually, 90% of the time, the plaintiff also bears the duty to begin. But there are some cases where the way the defendant pleads will determine who bears the onus and who has the duty to begin. And a typical example would be where the plaintiff sues on a suretyship. The defendant then pleads that he signed the suretyship under duress. Now, in a case like that, all the plaintiff is going to do is come to court and say, here is the original suretyship. The defendant admits the signature. I hand up the suretyship and I rest my case. What it means then is that the defendant attracted the duty to begin and the onus of proving the duress. So the whole thing gets reversed, and that happens because of the way you plead. The idea is to avoid attracting the duty to begin. Sometimes it's not possible. For example, the suretyship case. If the defendant admits a signature but has got a defense like duress or misrepresentation or fraud, then the onus and the duty to begin will switch. So what am I saying? What I'm saying is that if you are a defendant, you do not want to attract the duty to begin. One of the advantages of being a defendant is that the plaintiff has to begin. The advantage being that you then get to cross-examine the witness first. It's your opponent's witnesses who gets cross-examined first. That is an advantage. It's a strategic advantage. So, depending on the cause of action and how you plead, just be alive to the fact that you might shift the onus or the duty to begin. Right, let's go on to the next phase, when pleadings close. When pleadings close, in other words, the defendant's plea is filed, it is a good time to call client in and discuss the pleaded case as it stands. Now, here's something that attorneys don't do. They don't call client in when the pleadings closed. This is something they do in trial preparation could be 2 years down the road. That's not good. Now you know why we have these 11th hour applications for postponements. I mean, you all know it. When you go to court, day one of a trial, here in Johannesburg or Pretoria, what happens? Someone's asking for a postponement. The matter doesn't go to trial. You know what's the cause of that? Because the practitioners, be it plaintiff or defendant, just found out what the case is about. And now they realize that their pleadings need to be fixed. So now they have to postpone. That's not good for client. Now client has to wait another 2 years to get back onto the trial roll. That's unfair. That's incompetence. Oh, by the way, many of you are used to the idea of taking cases on a contingency. Then it becomes a disaster because your firm is funding the litigation, and each time you postpone, you're going to have to wait longer to get paid. You'll end up getting liquidated this time. So it's not in your interests either. Now, once you've got the pleadings, discuss with client what the particulars of claim establish and what the answer is. Now listen to what client has to say about that. You may have to adjust your case concept slightly. As I told you, if you plead it correctly, you will not have to prepare amendments. I know that the rules allow you to amend, even at the argument stage. Any time before judgment, you can file an amendment. But trust me, it is not a good thing to amend. You amend only when you simply have to. Because you messed up on the facts or you pleaded badly, you have to amend, then go ahead and amend. But there will be consequences. Amendments are not an answer to all your problems. So try not to amend. Try and get it right the first time. So now ask what facts have become undisputed, because when pleadings are filed, there will be some facts which one anticipated will be in dispute when summons were served, now become undisputed. Now again, don't be lazy, write it down. Make a list of those facts that are now undisputed. Now, what are the undisputed facts? Those are the facts where it turns out when you read the particulars of claim and the plea, the facts are common cause. Those facts that are common cause, both parties agree. Those facts that are now admitted, the defendant admits those facts. And then there's a third category you must be careful of. Very often defendants will file a plea, which is a bare denial, okay? So let's take a simple example. Plaintiff pleads that defendant drove through a red robot. Defendant's response? Defendant denies. Plaintiff is put to the proof thereof. Now what has happened? What has happened here is that the defendant, that's a material fact of your client's case. The defendant denies it, but presents no basis in fact for the denial. And that's what a good lawyer is looking for. When you see a denial in the plea, now look for a factual basis for the denial. If it's not there, put that on the side of the undisputed facts, because they have no basis to dispute. That's just a bare denial. Now ask the next question. Do the undisputed facts support your case, your client's case, or does it support your opponent? If you've prepared your case well, you will mostly find that the undisputed facts will support your client's version. If it does not, there's a problem. Go and go and see where the problem is. You may need further instructions. You may need to bring in more facts, other witnesses, etc. If you can't fix it, then Rule 41A might be your answer. Now do the next thing. Make another list. Again, write it down. Don't be lazy. Make a list of those facts that have become disputed. Because those are the facts that you need to prove on a balance of probabilities in order to discharge the onus of proof. Now apply your mind. How do I go about proving these facts? So take each fact and say, how do I do this? Well, you will do what we call a proof analysis. So in other words, you take each material fact and you say, right, who's going to present the evidence? Who will be the witness? Will there be more than one witness? What will these witnesses say? Are they available? Can I present them as relevant and admissible? Will their versions be accepted as probable? Then you need to look at what documents will I need. Now, as I told you, contemporary documentation is highly persuasive. For example, if you're suing on a contract, there's nothing better than a written agreement signed between the parties. It is far more easier to prove than an oral agreement between the same two parties. Oral agreements are difficult to prove, but a written document is fantastic. It works brilliantly. Now analyze the plea. Does it disclose a defense? If so, what is the defense? Can your client provide an answer if you're a defendant? Now, if you're the plaintiff and you don't see a defense, don't waste time, complain about it. Take exception. Now, here's a strategy which many practitioners use. They say, well, that plea is acceptable. It doesn't disclose a defense. But I'm going to keep quiet about it. Let's go to trial and I'll raise it there. Well, that strategy doesn't really work because you can get the same result immediately. You can do a number of things. I told you, you can take exception. You can also call a case conference with a judicial manager and say, Judge, look at that plea. There's no defense. There's no answer to the plaintiff's particulars of claim. It's an abuse. The judge will deal with it right there and then. And usually, the judge will give the defendant an opportunity to amend or will recommend that the matter be settled. Now is the time also to update your chronology document, because now you've seen the discovered documents, you've read the plea, and you will be in a position to add to the chronology. Finally, and most importantly, can you identify the issues that emerge from these pleadings? And again, I say, write it down. This is an absolutely essential step. One of the things I'm going to recommend you do, and it's a very good strategy, before you go to a pretrial conference, always send an agenda to your opponent. The agenda must include a list of admissions that you want, including a list of documents that you want admitted without proof, and very importantly, write down what you consider are the issues between the parties and invite the defendant to either agree with it or to provide their version of what they see as the issues between the parties. Don't go into a pre-trial either with your opponent or with the judge without sending this agenda in advance, because one of the things you don't want is for the other side to come to you to the agenda and say, oh, I need to take instructions and I'll revert. Now that's a famous response. Most of you have seen it. Most of you have used it. You get asked a question. You say, I'll take instructions and revert. And then mostly you never revert. Doesn't help. Judges are aware of this. When you give advance notice, they can't come and say, well, I need to take instructions and revert. Well, what were you doing in 2 weeks? You've had it since 2 weeks ago. Well, that is the technique. As I say, there needs to be transparency. Don't try and ambush your opponent and don't allow them to ambush you. Send the admissions that you want, write down the issues and send that to them and discuss it. The idea is to do the work between you and your opponent and give the case managing judge as little work as possible. Now we come to this question of discovery. If you're going to read the cases about why we need discovery, you will see that it is an essential element in this process of dispute resolution, because it is the discovered documents that tell you what the issues are, how they can be disposed of, and most importantly, discovered documents are highly effective in reducing the issues or confining the issues. It's very difficult to argue with a document, especially documents that are signed by both parties. Now, I want to pause here for a moment and talk to you about two forms of discovery that we're currently dealing with. The discovery, as you will see it in our rules now, I think it's Rule 35. Most of us have dealt with these schedules to the discovery affidavit and so on, where we indicate if it's an original or a copy and if it falls into Schedule 1 or Schedule 2. You've all done that. We changed the way we do discovery now. This thing about wide discovery is no longer allowed. Now, one of the things that you hardly ever see in South Africa, I must tell you, there are few cases where I've come across this. It's called document bombing. Some of you may have heard of this thing called document bombing. What this is where one of the parties overwhelms the other side with so much documents that they can't manage them. I've seen this in the United States, where the one party will say, well, we're going to deliver the discovered documents to you. And what happens? Men in overalls pitch up with trolleys and bring in boxes and boxes of documents. Now, not all litigants can afford to pay for the management of those documents. Now, judges know this, and they know it's used as a strategy to frustrate the other side. And now, with electronic discovery, electronic documents, it's become even more of a problem, because we generate electronic documents all the time. In fact, currently, as we speak, I don't think there are any documents that are generated manually. Everyone produces documents on a computer, even a very small business, a small spaza shop, or even, I've got to go through questions. Oh, sorry. I'm going to go on until I finish discovery, then I'll get to some questions in a moment. But let me finish discovery. All of these businesses generate electronic discovery. It's on a computer. I know I'm not supposed to tell you stories, but this is quite amusing. I was in the Free State in Bloemfontein, and unfortunately lawyers have to go there from time to time. But so there I was in Bloemfontein, and I was presenting a course. I wasn't in the SCA. I was presenting a course for the Law Society, and I had a whole lot of attorneys there. And one of them came to me during a break and said, "Look, I've got a problem. Can you help me?" I said, "What's the problem?" He says, "Well, he issued a summons in a goods sold and delivered case, and the defendant did not enter appearance to defend. And this was in the magistrate's court in Bloemfontein. He said that he applied for judgment by default. The magistrate refused the request, and the reason was the magistrate said he wants the original documents. You must file the original documents before he can give judgment." So now the attorney is thinking, but what is an original document now? Because the invoice that he handed to the magistrate and the delivery note were produced by the company's computer. And that copy is similar to any number of copies they can print out of the computer. The original is on a hard drive. And the only way they can prove an original is to access the metadata on the computer. So I explain all this to this attorney, and he's looking at me very perplexed. And then I realized what the problem was. He's thinking, how on earth am I going to explain this to the magistrate? Now remember, this is Bloem, eh? They're not going to understand all this. So I said to him, "Listen, let me not waste your time with electronic discovery. Go to a stationery shop, buy a rubber stamp that says original. Go and stamp the same invoice and send it to the magistrate." He rang me up a few weeks later and he said he got judgment immediately. So South African lawyers have not got into the harvesting, preservation, and presentation of electronic documents. And now it's opened up completely. Remember, we now have electronic signatures. We have emails. I mean, in the past, we wrote letters to each other, which a messenger took across town. Now it's emails. Everyone generates hundreds of emails per day. These things have to be discovered. SMSs, Instagram, WhatsApp, all of those social media networks, they're all generating documents now. And those things have to be discovered. So how do we deal with it now? By coming up with narrow discovery. When we say, what's the difference between wide discovery and narrow discovery? Wide discovery is where you have license to discover everything. So you want to document bomb your opponent? Be my guest. But with e-discovery, the bombing could run into thousands, hundreds of thousands of documents. Now, how on earth are you going to deal with this? This, by the way, has resulted in a whole industry in the United States, in Europe, and in the UK. It's called outsourcing. It's called legal process outsourcing, LPO, you might have heard of that, where attorneys find it cheaper to send the documents to a smaller firm or even a company that specializes in this, and they do it, and they will then pull out the relevant documents, sequence them, and so on, so that it can be discovered. How did we solve this problem? In the UK, for example, those courts now compel the parties to agree on a budget for discovery. So the parties must agree, we're going to spend so much money only on discovery. We're not going to go beyond that. We haven't got there yet. Look, one day we'll get there, but we're not there yet. But one thing that's happening in this country, if you are going to document bomb your opponent with documents that are not strictly relevant to the issues that you agreed, you will be penalized. You'll be disallowed the costs of discovery, and there may even be a punitive cost order. So what we want you to do now is to discover only those documents that are relevant to the issues. But that's the first step only. The second step is you are still required to consult your opponent and agree on the presentation of those documents. If your opponent has no factual basis for disputing a document, they are supposed to admit it. The same applies to you. If you don't admit a document, especially an electronic document, it means then that the other side has to discover the metadata in order to, and then you have to see in what format the document was presented. You have to look at the properties on the metadata to see if the document was tampered with, added to, clauses removed, whatever. You need to go into all of that. So it's a long process and an expensive process. The idea is to agree that you will discover electronic documents without having to discover the metadata. Now, what I'm going to do, show you something. Here's a book. It's called A Guide to E-Discovery in South Africa. It got published on Friday last week. Okay? It's a good book to get. It tells you about electronic documents. It helps you through all the jargon that has been developed around e-discovery. I know that the rules board is working on a set of rules for electronic discovery, and they are going to be, I don't know when they'll be published. We've been saying over the last 5 years it'll come out, still hasn't come out. The authors of that book have made representations to the rules board and given some drafts. But for now, you can use that book, and all of you in all your firms, or if you're a practicing advocate, you'll need to convert your practice to deal with electronic discovery. So I'm going to stop there for a moment. I will carry on with e-discovery tomorrow, and then go into the next phase of the process. For now, I've got your questions, the questions that came through, and I'm going to try and get through as many as I can. Monica McDonald, can the evidence be admitted into evidence if it has been discovered and then the case was referred to mediation, which fails? Then you go to trial. Evidence, any evidence, requires proof to the satisfaction of the court before it turns into a fact. So how do you do that? It can be presented as an admission. It can be presented as a document that was discovered. If it is not in dispute, it is admitted into evidence. If it is disputed, then that is a fact that requires to be proved. Now, if the matter is interrupted and the parties go to mediation and the mediation fails, then nothing changes. It still has to be proved. She also asks about fees of a newly admitted mediator. Please clarify. You know, I told you we will eventually have tariffs by which you can make an assessment. But the best way to make an assessment is to talk to colleagues and see what are they charging. But the profession is so competitive that invariably, if you are appointed as a mediator, the parties are going to come and say, what are you going to charge? Let's agree a fee. So the idea is to agree a fee. And of course, you should know, if you price yourself out of the market, well, then you're out of the market. Victor, well, this is a comment that the lack of uniformity is a serious issue, and it's frustrating. I agree, very, very frustrating. Unfortunately, we're going to be stuck with the practice directives. And I'll tell you what's the worst thing about practice directives. They also change all the time. I mean, if you look at Gauteng, they'll have practice directives this week, and then next week there'll be a different one. And to keep up with this is a bit of a nightmare. But I'm hoping that we'll have uniform rules soon. And then Pumezo asks a question that often comes up. Can you force the other side to meet with the judicial officer in a case conference? Well, he's obviously talking about the attorney who delays the matter, the one I spoke to you about. Well, that's what case conferences are meant to do. What happens is you apply for the matter to be referred to a case manager. You write a letter of a letter of motivation, which tells the judge why you need a case manager. One of the points you make in your motivation is that you've got a opponent that's impossible to deal with, and judges know about this. I've come across cases where the opponent didn't turn up. So what did the judge do? The judge had a letter written to this opponent to say, on such and such a date, present yourself at court to explain why you shouldn't pay all the costs in this matter de bonis proprius. That has happened here in Pretoria in quite a few cases. So they can be compelled. You can't ignore a judge. When a judge says, come to a case conference, are you going to, you can always show your middle finger to an opponent, but you can't do that to a judge. Dwight Langerveld's having trouble to secure a Rule 37 pretrial conference. Now, there's two things here. If your opponent doesn't give you dates and doesn't attend a pretrial conference, simple. Write a letter to say, on these dates, we requested you to agree to a pretrial. You have failed to respond. You don't cooperate. Put it on in the letter, and then you end your letter by saying, your attention is drawn to Rule 37(9)(a). It will take a very stupid attorney not to realize that he is in peril of picking up a de bonis proprius cost order. That will get them going. Otherwise, the best way is to deal with is to use a letter of motivation to write to the DJP, and he will appoint a case manager. Now you write, Dwight's talking about approaching the chief registrar. They are usually a waste of time, the registrars. They don't do anything. So It depends on which court you are in. I can tell you what happens in Gauteng, also in the Western Cape and in the KwaZulu. You can write to the DJP or the JP's office and request. And there, if you have an impossible opponent, make mention of it. Okay. Tyler wants to know if we're, helping a witness with chronologies and so on, does that amount to coaching your witness? No, it doesn't. There's a difference between arranging the version so that the witness can present it correctly and telling the witness what to say. When you tell the witness what to say, that's coaching. It's unethical. Don't do it. But arranging chronology documents and so on, not a problem. That's not coaching. And when do you file the document? Well, look at the practice directives. If you're in the provincial division, in many provincial divisions, there's no requirement for chronology documents. Gauteng started it with chronology documents for your opposed motions and also for appeals. But most of the other divisions don't have it yet. But all I'm saying to you is have chronology documents. And is it necessary to serve it on the other side? No. But when it comes to appeals, SCA and Concord, you are expected to file a joint chronology document. In other words, both parties get together, agree on a chronology and file it. If there are disputes over the chronology, then the parties file separate chronologies, okay? In a trial, if you hand up a chronology to the judge in opening statement, hand a copy to your opponent. Right. I have an exception. Is a chronology document necessary? It depends on the facts. I'll give you a good example. Not really an exception. It's actually a special plea of prescription. That's where you need a chronology document to show this is when the cause of action arose. This is when the party should reasonably have known. This is when action was instituted. 3 years gone, prescribed. That's a chronology document. Very helpful. Any other exception, like you don't disclose a cause of action? Well, depends on the facts. You might require a chronology document. Okay. If there's a criminal case against the accused, when is the best time to commence a civil claim? There isn't a best. You're bound by the law. The best time to commence a civil case is as soon as your client knows that there is a cause of action. If you wait for the civil case to end, you may find yourself prescribed. Please go and read. There's a very recent Constitutional Court judgment. I can't remember the name now, but it's very recent, where the Constitutional Court deals with what are the facts that a plaintiff needs to know before prescription starts running. And if there's a criminal case involved, there may be a case against the state. You also have to comply with Act 40 of 2002. Right, Masika has a question. When an applicant institute motion proceedings and then the respondents do the counter application, is the counter application instituted under the same name and case? Yes, it can be done in the High Court. The parties will even call each other applicant and respondent, but you'll say that in the counter application, the parties will be described as in the main application. There's in our magisterial division seem to be having troubles with this. Hey, I can tell you, there's there's no limit to the number of troubles magistrates can make. And it all boils down to incompetence, nothing else. There's really not much you can do about that. What can you do when there is a court order in favor of the applicant, but the respondent company is liquidated or in the process of being liquidated? Well, I told you, when you issue summons, one of the things you should ask is, will the judgment be satisfied? If it looks like this defendant company will go into liquidation, you have to ask your client if it's worth proceeding anyway and then going into an insolvency inquiry and then possibly suing the directors, holding them personally liable in terms of the Companies Act for the debt. So you know, when someone liquidates a company to avoid a creditor, it's not always the answer. With the current Companies Act, you can hold the directors liable. Are there more examples where duty to begin shifts to the defendant? Or there are a number of examples. It depends on the facts. Where you rely on a document, a contract, all contracts, if the other side admits the contract, admits the signature, but puts up a defense like the goods were defective or the wrong goods were delivered, that's another good example. All causes of action based on liquid documents is also a good example. When do you hand up a chronology document? Those cases, there are many cases where the practice directives will tell you when to hand up not hand up, but to file a chronology document. In which case you won't have to hand it up, the judge will, or the judges will have it in the file. If there's no requirement for a chronology document, let's say you in a opposed motion outside of Gauteng, then you can file it with your heads of argument, or when you stand up in court, you can hand up the chronology. And you say, well, Lord, may I hand up a chronology to assist the court, and hand it up and then give your opponent a copy. In a trial, it's a very good idea to hand up a chronology, your main chronology document, at the opening address. And I'll tell you how you do that later. How do you go about objecting to a 41A? Look, what I suggest, Tanya, is that go and read 41A. It is very well drafted and it sets out all the steps, step by step. And I've also dealt with it in the Lexis. By the way, it's in your notes. Go and look at your notes. I've written it all up there for you. Okay, I think I've covered all the questions for now. Yes, so what I'm going to do, I'll stop now and I'll continue tomorrow with the electronic discovery. I'll say a little more about it because it's what's going to occupy you for the rest of your careers. And then we'll continue with the rest. Okay, thank you. And I'll see you tomorrow. I just need to make a note. I'm on 50.
First we did quickly shut down this. In the leave now.